In this video, Sarah Grusin and Katie DeBreer, the lead lawyers for the National Health Law Program and the Florida Health Justice Project, will explain why this class action was filed and why the issues are so important, who the plaintiffs are, and what brought this litigation team together.
As shared in our companion video, Florida's Unwind process is plagued with problems and almost 1 million people have lost coverage. This lawsuit does not address many of the problems, like Florida's failure to stick with the prioritization plan and long call center wait times. But it does address Florida's Medicaid termination notices, which currently violate due process requirements under both the U.S. Constitution and federal Medicaid law. Before Sarah Grusin from the National Health Law Program explains what due process means and why it's essential, I want to share with you a little bit about our plaintiffs. In late May, Cheyenne D., a young mom with a 5-month-old son and a 2-year-old daughter, learned that she and her daughter would lose Medicaid at the end of the month. This was terrifying news. Her daughter, CD, who was born during the upheaval of the COVID pandemic, has cystic fibrosis. CD has been in and out of the hospital, seen by multiple providers, required special medical daycare and medical equipment, and prescribed a cocktail of medications, including a new drug proven to dramatically extend the lives of people with cystic fibrosis. Cheyenne was sent a 12-page termination notice, which she found incomprehensible. She did not understand what the notice meant when it said Medicaid was ending because, quote, your household's income is too high, and, quote, you're receiving the same type of assistance from another program. Losing insurance was bad enough for Cheyenne, a new mom entitled to 7 more months of postpartum Medicaid coverage. But for her daughter, it was unthinkable. The child ended up in the ER without insurance, and the family racked up medical bills that have since been sent to collections. While AV, another plaintiff, is basically a healthy 1-year-old, she needs health insurance and has gone months without coverage. Her parents were also sent an incomprehensible notice stating that, quote, her Medicaid was ending because she remains eligible for Medicaid under a different Medicaid coverage group. Her parents thought she should still be eligible for Medicaid based on their household size and income. They did not understand the notice's description of how to appeal before AV lost coverage and have had a nightmarish experience going to other subsidized insurance programs like CHIP and being told to reapply for Medicaid.
NHELP and its network of state-based health law partnerships had been anticipating Unwind coverage losses and preparing to support our partners along with affected individuals and families. Partnerships including Florida Health Justice Project worked hard to educate enrollees, agency officials, and policymakers. In spite of everyone's best efforts, the process has been confusing and chaotic in many states. Our case is arguing that, in Florida, the termination notices being sent to people are so bad that they violate the Due Process Clause of the 14th Amendment and federal Medicaid law. More than 50 years ago, the Supreme Court established that fundamental due process requires that before someone loses a critical public benefit like Medicaid, the state must send a clear and understandable written notice explaining why it has decided the person is no longer eligible and how to appeal if the person thinks the decision is wrong. Due process is not just an academic legal theory. If states don't provide it, people can be hurt. Medicaid eligibility is incredibly complex. There are dozens of eligibility categories with different income limits, different rules for counting income, different age limits, and other various requirements. Some categories have resource and asset limits. Some do not. Some require individuals to have particular medical conditions. Others do not. And within a single eligibility category, the income and asset limits vary by household size. In a program with this much complexity, and with the state processing 5 million cases over the course of the 12-month unwinding, it's not surprising that mistakes in eligibility decisions are being made. And that is precisely why the Constitution and the Medicaid Act require that individuals receive adequate notice and a meaningful opportunity for a hearing before losing coverage. These safeguards are necessary so that individuals can identify mistakes and be able to challenge and correct the decision at a pre-termination hearing. Otherwise, the harm is already complete. Adequate notice is not a mere formality. It is a necessary safeguard to make sure that eligible people keep their coverage. And everyone is entitled to that safeguard before the states cut off their health care.
Florida officials have known for years that the notices, quote, generate confusion, and that the description of ineligibility is not sufficiently explicit in terms of an explanation. Those are their words from 2018. But they didn't fix the notices in 2018 or during the pandemic's 3-year moratorium on termination. Instead, they've gone full steam ahead with inadequate notices that fall far short of what's required under the law.
NHELP and Florida Health Justice Project only litigate as a last resort. But we had to file this lawsuit because the state's failure to provide adequate notice and a meaningful opportunity for a hearing before terminating Medicaid coverage is hurting people. Mistakes are happening now, and people are losing their Medicaid coverage.